Civil proceedings mean nothing to the parties. This is because the courts are so lax. Our civil justice system is a defendant system. The reason is that the courts do not take the provisions seriously. Friends, this is a very concerned and relevant observation made by none else other than the Honorable Apex Court. It was a bench consisting of Justice Chandrachud and Justice Shah, and these observations have been recorded by Justice Chandrachud. These observations had to be compulsively noticed because these these are in fact a very scathing and truthful comment upon the manner of functioning of some of the civil courts. I have been a part of the justice delivery system at the trial level for a number of years, and the lawman in me feels very happy that these observations have come from the Honorable Apex Court. I am reminded of a civil revision matter. The facts were like this. The evidence of the plaintiff in a civil suit was closed by the trial court after that party had availed of as many as about 73 or 74 or so adjournments. It did not reduce its evidence, or it did not reduce evidence incomplete, and its evidence was ought to be closed by the court. Thereafter, the evidence by the party opposite, that is the defendant, came to be recorded. It was at this stage, as the facts revealed, that the plaintiff filed an application for the framing of an additional issue, which would have, as per the view of the plaintiff, represented a rebuttal issue, and the issue came to be framed. Obviously, the onus to prove that issue was upon the plaintiff, and he came to be afforded an opportunity to reduce evidence. On point of fact, I do recollect the issue was not warranted. It was not required to be framed because it did not arise out of the pleadings of the parties, but it did come to be framed. I allowed that petition in limine. Now, this was one rare, perverse manner of exercise of jurisdiction by the civil court. I can assure you, friends, the procedure law, be it in the criminal side or the civil side, the law in place, the procedure law in place is absolutely in order. It's just that we do not implement it properly, appropriately. We do grant adjournments for reasons which may not necessarily be appropriate. I would not say on the drop of a hat, although the instance I have quoted was one in which the order was perverse from any and every angle. I do recollect that I put in place a mechanism for disposal of the certain categories of cases